Hey everyone. So the hearing on the Katie case subpoena has just finished. I had to frantically write notes, which is always interesting. So I'm going to kind of summarize this as best possible. I will just make to make everyone aware. I am actually registered deaf. Not completely. I can hear, but it's hard when I can't lip read, or if there's background noise or someone's really quiet. And as I always find with Judge Lyman, he's either sort of like quite a stop-start talker, or he's cutting in and out of something. I always find that with him. I did actually hear the other lawyers quite well. So representing Jones was Kristen Thaler, I think that's her name. Lively was Kristen Bender. I can't remember her name. I think that begins with a K. Wayfarer was represented by Kevin Fritz, and Katie Case was represented by Maxwell Breed. So Tala opens by basically saying, well, Katie Case does not object. So that's her opening point. Then she goes to say that the documents that she's seeking are critical to Jones' works, that the website in question is at the heart of the Jones case. She says that the documents are also important for the credibility of Melissa Nathan. And the conflicting testimony as well, because obviously Melissa Nathan has testified that she did not have any involvement. Katie Case has said that Melissa Nathan was involved and directed Katie Case. And Tala, she rightly points out, in fairness, that both can't be true. Judge Lyman, he was quite critical actually of Tala, so credit to Lyman a little bit. We'll obviously see what his actual ruling ends up being, but I thought he was like not so lopsided in this hearing. And he was a lot more respectful towards Fritz than he usually is towards any Wayfarer counsel. So Lyman sort of pointed back and said, well, if they were so critical, why not subpoena for them in September? And Tala said they did not know Melissa Nathan would deny being involved, which is just ridiculous. Because, like, if you become aware of these documents, and bear in mind, Katie Case's deposition was in early September. Katie Case, you still subpoena the documents. You still get the documents. I mean, it's still past the deadline for fact discovery, document production, but it's still better to. She would have had a more reasonable argument back in September than she does here in November. The judge was very critical about that. Then Judge Lyman said, well, but Melissa Nathan and Jed Wallace deny any involvement. And Tower said, well, that's why we came back to Katie Case. And I think Jed Wallace and Melissa Nathan, their depositions were done like on the last days of the deposition windows, like, almost middle of October. So it was a good 6 weeks from Katie Case's deposition to Jed Wallace and Melissa Nathan's depositions. That she could have just attempted to get the documents during that period, and I think Judge Lyman would have been a bit less scathing about it. So Lyman then asked, well, why not a trial subpoena instead of a discovery subpoena? And Tala did point out the Jones case does not actually have a trial date. So what she was saying is, well, we want these documents while they are fresh. At which point my own mind was like, okay, well, why not back in September? Then they would have been even fresher. But that's just me. That's just the kind of skeptical side of me. So Lyman then said, he says, oh, you say Katie Case testimony is relevant. The documents would have been equally relevant. Why not subpoena them before closed discovery instead of waiting to see what Melissa Nathan or Jed Wallace say in their depositions? And basically, Tala did not have a cogent argument for that, in my opinion. She then kind of went on to say that Wayfarer, Jen Abel, etc., they don't have standing to complain about this subpoena. Because basically they've got no interest in the documents, which effectively confirms that Jen Abel is not kind of mentioned in them as being involved. And obviously Wayfarer, Baldoni, Heath, Sauritz, they're not involved in this. So then Lyman was quite sassy, actually. Lyman then said to Tala, are you saying, if in response to Tala saying that Wayfarer didn't have standing to complain about this kind of untimely subpoena, Lyman turned around and said, are you saying that if Wayfarer served a bunch of subpoenas after discovery, Jones would have no standing to come to me? Which was promptly walked back by Tala, who conceded that yes, Jones would have standing to object, but no standing to the documents. Tala then went on to argue that Wayfarer would not be prejudiced because they have no interest in the documents. Like, well, it's not going to prejudice them. Then Lyman asked, well, when did you contact Case, i.e. with the subpoena? And Tala said October 15th. So, yeah, that's quite some time after. I can't remember. I think the depositions, Melissa Nathan and Jed Wallace, they were around the 10th, 11th, 12th, possibly. So then Fritz comes in. He obviously straight out the store with the subpoena's untimely. He points out that there has been no shortages of motions to compel, and they could have subpoenaed. So, he's saying, well, if you wanted it, you should have gone at the earliest point you found out the documents were there. Which is fair. There have been absolutely no shortages of motions to compel in this case. Fritz also pointed out something we did not know, which was very interesting, was basically this, it's almost starting to sound like another Van Zandt now, like where Jones subpoenas or gets a subpoena, gets documents and Lively wants them. But again, like Van Zandt, no notice was given to the parties before the subpoena. So it was not compliant with the rules. He also points out a really good argument, actually. Well, if there was any, any uncertainty about, because Tyler was obviously saying, well, we're going to, we waited to see whether Jed Wallace and Melissa Nathan, what they would say, whether they admit it or deny it before subpoenaing. And Fritz pointed out, well, Nathan filed an answer back in March denying involvement. And, if it was that critical, then you should not have scheduled the deposition on the last day. Really good. He also said as well that he's like, Judge, this subpoena she served, it does not just seek these few documents from Katie Case. It actually seeks a hell of a lot of information. So what the subpoena actually asks for is it wants, and bear in mind I'm summarizing her, it wants communications about Jed Wallace, Melissa Nathan, Brian Friedman, and anyone else over a year-long period, which I think is, I can't remember, I want to say February 2024 to February 2025, I think around that. And Fritz says it does not even mention any social media posts. That was really interesting to find that out. Fritz then made a banger of a point to Judge Lyman, which almost felt like it was a bit of a swipe at Judge Lyman. He said, well, in addition to all of this, Judge, when we requested, with the agreement of Taylor Swift's lawyer, when I requested to depose Taylor Swift, he didn't mention her name because he probably would have been sanctioned, but he said a high profile, singer. After deadline, our request, Lively interjected and, tried to, said that it shouldn't happen. Lively opposed it, and you denied it without Lively ever having to show good cause. And he kind of alluded to, like, Judge, I just wanting to make sure that there's some, we stay consistent with prior rulings. So he's effectively, probably attempting to box Lyman into a corner, which I do worry that is more likely to make Lyman, push back and go against him, because Lyman is not, he's not bound by his own rulings. They're persuasive, and in theory he should apply the rules equally, but he is not bound by them. However, I thought that was a really good point to make, really important, because with the Taylor Swift deposition, like, okay, it was begrudgingly, but in theory, like Taylor Swift said, yeah, okay, I can do it, but I'm, and remotely as well, but I'm only available from after this week, and Lively was having none of it, so the judge said no to Wayfarer, so they never got to depose Taylor Swift, who was arguably had some involvement in all, and certainly some knowledge. By Lively's own admission, Taylor Swift had knowledge, which, could have been pertinent to the case. So yeah, I did a little happy dance in my head when that came out of Fritz. He also agreed with the judge, if Wayfarer started sending subpoenas, we would probably be hit with sanction requests, which was snarky. And then he reminds the judge the subpoena was issued improperly, because there was no notice given. Basically, what Tyler had done is issued a subpoena and then, gave it to the judge, come to the judge and said, right, judge, you need to enforce this. Lyman did ask Fritz, well, what about informal cooperation? There's nothing to prevent it, which, Fritz did agree that, yeah, there was nothing to prevent it, but I think Fritz was saying, well, if she's going to cooperate, she's going to cooperate. But Fritz did also point out that actually there was objections lodged by Case. It wasn't that, because, that was it, yeah. Tyler was representing that Katie Case had just said, yeah, okay. But actually there were objections lodged by her attorney to the subpoena. And there was also, it was a coercive thing anyway, because the Jones Works subpoena had told Katie Case that if she did not comply, then she would be named as a defendant. So, it wasn't true consent. It wasn't free consent. Then Maxwell Breed, so this is Katie Case's lawyer, he come in there and he said that he takes objections with the suggestion that document requests were not complied with. Now we've already seen, so the objections to the actual subpoena were in front of Lyman because they are sealed. So they couldn't go into great detail, but it was alluded to. So we don't know the details yet. And we've also seen on file on the docket that Breed has actually lodged take issue basically with Lively, suggesting that she was owed any documents, and that Case had not complied with some production to her because Lively's never even served her a subpoena. So but Lively's sitting there going, well, I'm entitled to the documents too, and she's not. Okay. Then we had so Tyler come back in at that point. She then went on quite a bizarre tangent about the documents that she's seeking from Katie Case being relevant to the spoliation motion. At which point Lyman got a bit snarky with that and said, well, you filed that motion some time ago too. Tyler was like, well, a few weeks ago, and it is a few weeks. Wayfarer have had their couple of weeks and have now replied, the other day. So, we are at least 2 weeks, going on for 3 weeks since that motion was filed. There's a bit of repeating of her original arguments. So Fritz got an opportunity then to respond to these kind of new sort of claims about the relevancy to the spoliation motion, which she had just brought up for the first time. And he said that he reminded the judge the spoliation motion was actually filed in Lively's case. It was filed by Jones. Well, obviously Jones and Lively filed one individually, but it was actually filed in the Lively case, not in the Jones case. And then he went on to say, not only was it not filed in this case, it was not filed in connection with the Jones website. So the spoliation motions have nothing to do with these, Stephanie Jones leaks and Stephanie Jones lies websites that she's claiming she needs the documents to prove that Melissa Nathan was behind them. And in her motion to compel, she did not raise the spoliation motions at that point either. So then at that point, then it kind of ended with, Judge Lyman basically saying, yeah, he's going to take under advisement. So no decision come out today. I'm sure we will hear quite soon. I would be surprised if Lyman did give this to Jones, though. I didn't hear anything from any of Lively's lawyers. Nothing was mentioned about Lively. No one spoke on behalf of Lively that I heard. I would be surprised if Lyman did actually gives this to Jones, because I think, along with Wayfarer pointing out the double standard that would be there, given their request to depose Taylor Swift after close of after the deadline for depositions, and their request was, I think about a week. Yeah, their request for deposition, their deposition that they requested would have taken place only about a week after Jed Wallace and Melissa Nathan's deposition. So, we are now several weeks, 2 months, past. Well, I think we're more than 2 months. Like, start September, and we're now heading towards the end of November. So we are some time away from when Katie case could have been subpoenaed. And he was incredibly critical of that. He was very critical of that. I also think as well that, Judge Lyman is very, although not much has happened in terms of Van Zandt, Judge Lyman is quite aware of the circumstances of that, of the fact that, there was no notice to parties, etc. It's a very improper thing, and to obtain documents that really there was no rights to be obtained. I don't think he's going to rush to have that situation repeat itself. In the sense, when I say that, I mean, I appreciate there's no sham lawsuit or anything in this situation, but, we're obviously talking about a subpoena that is alleged to have been served improperly with no notice to the parties and well after the close of discovery. And not only that, there's another further allegation that there was a cover note with the subpoena which basically threatened Katie Case to comply or be named as a defendant. I think I can't see Judge Lyman rewarding that. I think he's going to take it under advisement to make it appear that he has given thought and weighing up the arguments. But I would be very surprised and really disappointed, actually, if he granted this request. All right, that's all I've got for now. So I'm going to shoot off. Have a good night, everyone. And I'm sure there'll be something to talk about tomorrow.